Everyone, welcome to Free Info Friday. Hope you're all doing well. Today I wanted to talk about non-compete agreements. I thought of this topic because I know a lot of people are entering into new jobs or they may be leaving their previous job. So I thought people may be looking at their non-compete agreements or entering into new non-compete agreements. Now, if you're not sure whether you have a non-compete agreement, the chances are that you don't. A non-compete agreement is something that you're going to sign as soon as you start your employment. So it's something that you'll likely know about. Um, Non-compete agreements are agreements between an employer and employee that state that the employee will not directly compete with the employer after termination. Keep in mind that these types of documents can also be in between contractors, independent contractors. So just because you're not an employee, that doesn't mean that you don't have a non-compete agreement. Non-compete agreements have to be reasonable, and they have to be reasonable specifically in time, geography, and substance. So for time, typically a reasonable time is 1 year. It does depend on the job that you're doing, but generally you don't see non-competes for more than 1 year because it's hard to prove that it's reasonable to restrict someone for more than a year. They're also limited, as I said, in geography. Depending on what type of job you do and where you work, the geographical region that you're being restricted to has to be the region that you previously worked in. It can't be too overbroad. You can't say it can't be a national restriction. It needs to be a little more local, reasonable. And finally, for substance, that means the activities restricted. What you can and can't do has to be reasonable. Can't be unreasonable. You can't say something that someone will reasonably need to do. So obviously, these non-competes have room for interpretation. What is reasonable? It's hard to say. So these are very fact-driven cases. It really depends on what type of employment you have, what type of activities you are doing, and based on that is how you determine the reasonableness. If non-competes are overbroad, for example, let's say that a non-compete agreement restricts someone for 3 years and the court finds that that is overbroad. What courts do generally is they only partially enforce the non-compete agreement. So they only enforce the portions that are reasonable. So for example, with a non-compete agreement that restricted someone for 3 years, a court may look at that and say, it's unreasonable, we're only going to enforce that restriction for 1 year. So, like I said, it's very fact-driven. It really depends on your employment. So it is hard to give an overview of non-competes because they are so fact-driven. However, if you're entering into a non-compete and you'd like an attorney to review it, I would be happy to do that for you. Likewise, if you're a business owner and you're looking for someone to create a non-compete agreement, that's something I have done for other business owners and would be happy to help you out with. So if you have any questions about non-compete agreements, please reach out to me. If you have any suggestions on other topics you'd like to hear about for Free Info Friday, or if you have any other legal questions, please reach out to me. You can call, text, Facebook, email, whatever works best for you. Subscribe to my YouTube channel or check up on my LinkedIn and Facebook pages where my Free Info Friday videos will be every week. All right, I look forward to seeing you all next week and have a happy Memorial Day weekend. Bye.